Cornell Law School. U.C.C. Article 1, General Provisions, 2001. Part 2, General Definitions and Principles of Interpretation. Paragraph 1202. Notice, knowledge. Primary tabs. A. Subject to subsection F. A person has notice of a fact if the person 1. Has actual knowledge of it, 2. Has received a notice or notification of it, or 3. From all the facts and circumstances known to the person at the time in question, has reason to know that it exists. B. Knowledge means actual knowledge. Knows has a corresponding meaning. C. Discover, learn, or words of similar import refer to knowledge rather than to reason to know. D. A person notifies or gives a notice or notification to another person by taking such steps as may be reasonably required to inform the other person in ordinary course, whether or not the other person actually comes to know of it. E. Subject to subsection F. A person receives a notice or notification when 1. It comes to that person's attention, or 2. It is duly delivered in a form reasonable under the circumstances at the place of business through which the contract was made or at another location held out by that person as the place for receipt of such communications. F. Notice, knowledge, or notice or notification received by an organization is effective for a particular transaction from the time it is brought to the attention of the individual conducting that transaction and, in any event, from the time it would have been brought to the individual's attention if the organization had exercised due diligence. An organization exercises due diligence if it maintains reasonable routines for communicating significant information to the person conducting the transaction and there is reasonable compliance with the routines. Due diligence does not require an individual acting for the organization to communicate information unless the communication is part of the individual's regular duties or the individual has reason to know of the transaction and that the transaction would be materially affected by the information. Paragraph 1203. Lease distinguished from security interest. Primary tabs. A. Whether a transaction in the form of a lease creates a lease or security interest is determined by the facts of each case. B. A transaction in the form of a lease creates a security interest if the consideration that the lessee is to pay the lessor for the right to possession and use of the goods is an obligation for the term of the lease and is not subject to termination by the lessee, and 1. The original term of the lease is equal to or greater than the remaining economic life of the goods. 2. The lessee is bound to renew a lease for the remaining economic life of the goods or is bound to become the owner of the goods. 3. The lessee has an option to renew a lease for the remaining economic life of the goods for no additional consideration or for nominal additional consideration upon compliance with the lease agreement. Or 4. The lessee has an option to become the owner of the goods for no additional consideration or for nominal additional consideration upon compliance with the lease agreement. C. A transaction in the form of a lease does not create a security interest merely because 1. The present value of the consideration the lessee is obligated to pay the lessor for the right to possession and use of the goods is substantially equal to or is greater than the fair market value of the goods at the time the lease is entered into. 2. The lessee assumes risk of loss of the goods. 3. The lessee agrees to pay, with respect to the goods, taxes, insurance, filing, recording, or registration fees, or service or maintenance costs. 4. The lessee has an option to renew the lease or to become the owner of the goods. 5. The lessee has an option to renew a lease for a fixed rent that is equal to or greater than the reasonably predictable fair market rent for the use of the goods for the term of the renewal at the time the option is to be performed, Or 6. The leasee has an option to become the owner of the goods for a fixed price that is equal to or greater than the reasonably predictable fair market value of the goods at the time the option is to be performed. D. Additional consideration is nominal if it is less than the leasee's reasonably predictable cost of performing under the lease agreement if the option is not exercised. Additional consideration is not nominal if 1. When the option to renew a lease is granted to the leasee, the rent is stated to be the fair market rent for the use of the goods for the term of the renewal determined at the time the option is to be performed, or 2. When the option to become the owner of the goods is granted to the leasee, the price is stated to be the fair market value of the goods determined at the time the option is to be performed. E. The remaining economic life of the goods and reasonably predictable fair market rent, fair market value, or cost of performing under the lease agreement must be determined with reference to the facts and circumstances at the time the transaction is entered into. Paragraph 1204. Value. Primary tabs except as otherwise provided in Articles 3, 4, and 5, and 6. A person gives value for rights if the person acquires them. 1. In return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collection. 2. As security for, or in total or partial satisfaction of, a pre-existing claim. 3. By accepting delivery under a pre-existing contract for purchase, or 4. In return for any consideration sufficient to support a simple contract. Paragraph 1205. Reasonable time, seasonableness. Primary tabs. A. Whether a time for taking an action required by the Uniform Commercial Code is reasonable depends on the nature, purpose, and circumstances of the action. B. An action is taken seasonably if it is taken at or within the time agreed or, if no time is agreed, at or within a reasonable time. Paragraph 1206. Presumptions. Primary tabs. Whenever the Uniform Commercial Code creates a presumption with respect to a fact, or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence.